Okay, Underwood versus State. That's exactly what I was thinking. We were up here thinking you don't look a bit like Nancy Ryan.
And I say, thank God for that one, because poor Nancy would want to kill herself if I did. My name is Ed Weiss. I filed a notice of appearance in response. Ms. Ryan is unavailable today. I'm here on behalf of Joseph Underwood, the appellant. And today we're here for the issue that basically boils down to 4 words: by the sexual organ of. In this case, the defendant was charged with sexual activity with someone he has custodial presence over, and the victim was his daughter. The defendant was charged with basically a sexual battery, and the court, in the information that the state filed, they filed it as an alternative theory of penetration or union. In the jury instructions, they also charged the jury in the alternative of penetration or union. And what's key is, during the charge conference, when the state proposes its jury instructions and they say, Your Honor, they track the exact language of the information, defense starts to object and say, well, Your Honor, the Supreme Court has set forth a standard and this doesn't appear to be similar to that, and it almost appears as if trial counsel was looking at a computer screen trying to look it up. The court took what appears to be his rule book and says, well, let's look at 11.6.
What cases do you have that specifically say exclusion of those words from the information necessarily requires a retrial?
Well, Your Honor, if you look at Mungeon v. State, which is a Florida Supreme Court case out of 95, it says, while a general verdict must be set aside... do you have any cases, specifically on point that say if you exclude those specific words from the information is so fatally flawed that if there's a conviction, it requires reversal? Well, as far as the information, no, I don't have case law. And I would stipulate that the information at least charges the penetration properly. So the information based on penetration is a valid information.
Is that because penetration can be with any object and one has to be with a sexual organ, right?
Correct. Penetration can be by any object.
Right, but so where do you say it's stipulated or it's agreed? Where does that come from? Did the state stipulate and agree that the information is so fatally flawed because those words are left out that it necessarily requires...
I'm stipulating that the information is a valid information for the penetration theory. Therefore, we can't throw out the information.
No, I'm talking about for union. Do you have a case that you can give to me that says that when you leave those words out of the information, that the information is so fatally flawed that it necessarily requires a new trial?
I do not have a case. However, the statute reads that in order to prove sexual battery based upon the union theory, it must be by the sexual organ of the defendant having union with the sexual organ of the victim.
I know, but is there a case that you can give me that says if you don't specifically put that in the information, and then he's convicted, despite what the evidence shows, that he's entitled to a new trial?
I do not have a case on that, and Your Honor, I'm not...
I understand your argument about the two theory case and the special verdict form. I understand all that, but I couldn't find the case that specifically said that, and I didn't see that you had found one either, unless something new had come up.
As far as the jury instructions or the information?
No, the information.
And Your Honor, that's why I'm sitting here today saying I stipulate that the information is a valid information because it does lawfully charge the penetration. I'm not going to argue to you that this case should be vacated based on the information. I'm arguing that the jury instructions were improper as supplied to the jury. Okay, so
because I thought that you had made a pretty strong point of that in your briefs and in your argument. So we'll just move on to the jury instructions. Is that right?
Yes,
okay.
Your Honor.
All right.
But basically, the court looked at 11.6 and made a statement that's a little confusing. It says, the court said it's got a lot of parentheses for things that can be deleted. And then it goes on to read, upon which the sexual organ of the defendant, and continues reading A or B of the standard instruction. And yet then when it comes to actually giving the jury instructions, it left out that language of upon which the sexual organ of. Therefore, the jury was just basically instructed that upon union, it's just the defendant had union with the sexual organ of the victim. And per the statute, in order to prove sexual battery, the jury was...
What cases do you have, now we're talking about the jury instruction, what cases do you have that are directly on point that say, if that specific language, and you know what specific language I'm talking about, that specific language is excluded from the jury instructions, that it necessarily requires, it's so fundamental, it necessarily requires a new trial. If you list those for me.
Okay. Your Honor, this, we don't have, I did not supply one for a sex battery case.
I'm talking about a case that talks about the specific language that you say is not included in the jury instructions, that makes the jury instructions so fatally flawed that it's fundamental error and it necessarily requires a new trial.
Your Honor, the state filed notice of supplemental authority on Friday of several cases, and contained within those cases is a case out of the Fourth, also known as, and I want to make sure I get the case name correct, it's Gill v. State. And I'm reading out of the case the state just did a supplemental of Graves v. State, in which they parenthesized.
Did you file that? Okay, I see.
Gill v. State, and it says, reversing sexual battery conviction, notwithstanding the absence of the specific objection because the court's direction to the jury, highlighted by the prosecutor's statement indicating that union was an alternative to penetration, was fundamental error. And I would argue that the Fourth DCA recent case in which we filed notice of supplemental authority, because it came out after the brief was filed, of Sabri v. State, which dealt with a DUI case. And Sabri had a DUI...
Well, but I haven't read that case yet, and I'll read it. But does that case specifically say that if you exclude the language that we're talking about from the jury instruction, that the jury instruction is so fatally flawed that it necessarily requires a new trial?
I would say yes. Sabri is a DUI in which the defendant was charged in the alternative of alcohol or cocaine. And you can almost sense... I
don't see that case in my supplemental authority here, but you said that was filed Friday?
No, that is... We filed the Sabri case before Friday, several weeks ago.
I'll take it.
Sabri was charged alternatively of cocaine and or alcohol. And the Fourth DCA said there's clear evidence of an alcohol test over 08. When the jury was instructed upon, they were instructed that in order to find him guilty, you had to find either he had alcohol over 08.
Wait a minute. Or he had cocaine. It could very well be that maybe you and I are not on the same level here. I want to know if you have a specific case that talks about the very specific language that we're talking about in this specific case, and that specifically says if that language is not included in the jury instruction, that necessarily requires a new trial. I'm talking about the specific language that we're talking about in this specific case. This is a DUI case, and it involves other charges.
I agree it involves other charges, but it's very analogous for what it stands for.
Do you have a case that, I'll repeat the question one final time. Do you have a case specifically on point with language that we're talking about here?
We did not supply a case specifically involving this language. I would argue that the cases the state just filed notice of supplemental authority supports the position as that. And both Ross, although distinguishable from the case at hand, and Graves, both involve sexual battery cases in which what they're distinguishable on is they discuss of how the state didn't try on the union theory, especially in Ross, where the jury had a very specific verdict form in which they found sexual battery specifically based upon penetration. And they said since it wasn't mentioned, there was no evidence brought out, it wasn't there, it's not fundamental error. In this case, the state specifically relied upon the union theory. We have a general verdict form.
Well, didn't the prosecutor argue in this case that the penetration, was committed here, and that, you need to take a look at that, and specifically argued penetration to the jury? She
did argue penetration heavily. She also argued union at the end. Also, if you look at the facts of the case, on direct examination, when asked if the defendant ever penetrated her, the victim said no. In her deposition, she said no. Now, for some reason during cross-examination, the defense attorney re-asked it and she said yes, and then shortly thereafter she recants again and says, well, I'm not saying that he penetrated. When asked, so you're saying he had union and penetrated, she says, I'm not saying that. And the very last part of the closing argument of the prosecutor is, she states, there's different types of sexual touching without penetration, and then argues he rubbed his penis on her vagina. So even though she does spend a lot of time discussing penetration, she does rely upon the union theory. And again, the instruction is incomplete as to union theory because it left out, it's basically telling the jury, you can find the defendant guilty of sexual battery solely by proving lewd and lascivious molestation. Lewd and lascivious molestation is having union with the sexual organ of the victim by any object, whereas sexual battery requires union to be by a sexual organ of the defendant. And that was not done in this case. In this case, and I would also argue, I'm arguing that it was preserved. The defense does object, renews its objections as previously stated, and makes the court aware, and even the court read 11.6, making them
Do you object to the general verdict form?
No, they did not object to the general verdict form. I will admit to that.
So what effect does that have on the decision in this case?
I say none. The jury instructions were objected to. He renewed his objection. He made the court aware of the error.
But you're now relying on the fact that there's a general verdict form and that you didn't object to that. And a general verdict form allows the jury just to make a finding on any theory that's presented to it, guilty or not guilty, proven or not proven. And if you wanted a specific verdict form, you certainly could have asked for it and said, we want to specify union, penetration, or not guilty, right?
I admit that he could have specified.
And it seems to me like your primary argument is there was a general verdict form and the jury could have found guilty based on union rather than penetration, or penetration rather than union, and we don't know. One's appropriate, one's not. And you didn't object to the general verdict form.
That is the gist of the argument, is that we don't know why the jury decided what they did. And both Mungin and this court said, and this court stated in Allen, on appeal, the question for the court is not whether evidence existed which would support conviction upon the valid theory.
Your argument is if there's one appropriate and one that's not appropriate, and there's a general verdict form, then it necessarily requires reversal because it could have been, the jury could have decided on the inappropriate theory.
Yes, Your Honor. And the dissent in the Graves case, I think, puts it best when they say that it is fundamental error. And the Fourth DCA in Sabri did find, admittedly it's a DUI case, but it is very analogous. And the Fourth DCA found that it is fundamental error because the jury was instructed only that simply having cocaine was sufficient, and when in reality it's cocaine to the extent his normal faculties were impaired. And I see I'm down to 2 3/4 minutes. I'd like to reserve the remaining time for any rebuttal.
May it please the Court, my name is Wesley Height and I represent the State on this case. The first issue raised is a challenge to the charging information, and I think appellant has agreed that the information puts the defendant on sufficient notice. So really the entire concern of the Court is to the jury instructions. If you look, and it's the State's position that the jury instructions in this case clearly were not preserved. If you look at the charge conference and you look at the exchange between counsel and the court, the defense counsel begins saying there's 2 ways to prove this, and he starts raising union and penetration. Then for some reason there's a whole exchange about the Jessica Lunsford Act and when exactly was the statute passed, and they go in that direction. And the court stops and says, all right, I'm looking at the standardized instruction. It's got a lot of parentheses that need to be deleted, and I need to see what applies. Mr. Lahr, defense counsel, help me. Help me understand this. I don't know. I'm trying to figure out what to give and why. And Mr. Lahr, defense counsel, does not come back and explain. He jumps to, well, the statute back in 2005 says a person who willingly consent to the victim, which I'm not even sure what he's saying there, to engage in an act that constitutes sexual battery. You have to read both. So, he's jumping around, and they're talking again about the timing of the statute, but that's not a proper objection. This issue is not preserved. This was day 2 of the trial. Afterwards, the court makes the reference on the record that on page... the court makes reference at the end of that day that I've handed out the jury instructions, everyone has them, and sends the jury home. They come back the next morning, they wrap up the trial, they instruct the jury, again, no objection to the instructions, no objection to the verdict form. If you look at the fundamental error, what's missing from this instruction is a reference to the appellant's sexual organ. And clearly everyone understood that the entire argument is whether the defendant's sexual organ had contact or penetration with the victim's vagina.
Counsel,
yes.
How do you know? You say everybody understood. What evidence do we have that everybody understood? I mean, his argument is the jury didn't understand it.
I think you look at the opening. If you look at the state's opening, the state says the evidence will show the defendant raped her and did her.
But you got to focus on the instruction, not on what the argument was. Look at the instruction and tell me why.
Well, admittedly, the instruction is flawed. But the question is, when you have fundamental error, is whether it's so flawed in this instance to require a new trial. And it's the state's position, clearly it was not. If you look at the cases that we cited that talk about if you don't have a disputed element, if it's not contested, the entire argument is defendant's sexual organ penetrates or has union with the vagina of the victim. State's closing. He's sexually abusing his daughter, rubbing his penis against her vagina. He admits intercourse. That's what the entire argument was about. This case was clear to all parties. The defense does not say we had mere contact. The defense's argument is not that we had some type of contact that does not rise to the level of sexual battery. The defense's argument was he didn't do it, she's lying. He did not ask for the lessers. He comes back with he didn't do it, she's lying. Read his opening, read his closing. That's the entire argument here. And what ultimately led to his conviction was the fact he confessed. He made a tape statement. Even on the stand, he's talking about his erect penis, may or may not have come in contact, may or may not have leaked. In his statement to the police, he talks about, did you have sexual intercourse 10 times? He says, not that many. This victim thought she was pregnant. There's no confusion here as to whether we're having mere union with some body part other than the defendant's penis. Everyone understood. Admittedly, the jury instruction is flawed, but that's what objections are for. There's no objection by defense that puts us on notice of any of this. When you read the instruction, I've read it now numerous times, I'm still confused at what defense counsel was trying to say. In that situation, I would submit that he should have gathered himself and come back the next day, because he's trying to pull the website up, he's struggling, he's saying, Your Honor, he's talking about union with, their discussion of Jessica Lunsford, which I have really no idea what they're talking about there, but the concentration of the entire case is, when you read the instruction as it was given, the defendant committed an act upon the victim in which he penetrated or had union with the vagina of the victim. We're talking about the defendant's penis. No one, the sexual organ of the defendant, no one was confused. The jury fully understood. The defense was, she's lying, not that I didn't have some type of penetration or contact, but she's lying and I had no penetration or contact. I mean, that is his argument. When you read Delva talks about the fact that the defendant had drugs in his car. And the defendant's argument is, with the drugs in the car, they're not mine, I didn't know they're there. They omitted the Chacon element, the illicit nature, and the Supreme Court says it doesn't matter since it's not in dispute. It doesn't affect his defense of, not my drugs, I didn't know they're there. This is very similar when you look at the Graves case cited by the state as supplemental authority. The jury was misinstructed with no objection about union. In that case, they affirmed because the state's concentration and the entire focus was on penetration in that case. So again, this authority, we assert, would lead to you affirming. There was no objection, there was no notice in this case, and we ask that you affirm.
Once again, the state just admitted that the jury instruction is flawed, and they cite their cases, but in their case of, I believe it's Ross.
Well, didn't you say earlier that if there were evidence of penetration, then you could not succeed on appeal?
No, I said as to the information. On jury instructions, it's different. When you're on a general verdict form and there's alternative theories, and one is a legally invalid theory, which what we have here based on the improper jury instruction, then this court is required to reverse under Mungin for a new trial because unless there's a way to tell why the jury rendered its verdict. And this isn't like the second case the state cited in its supplemental authority where a specific jury verdict form was rendered. In the first case of Weaver, Weaver cites to Reed in which the Florida Supreme Court held where defective instruction could only constitute fundamental error if malice was disputed at trial. And here,
the prosecutor argued in closing penetration. The young lady disclosed all this because she thought she was pregnant from her father. Her father, when questioned about did you have intercourse with her 10 times, he said, no, not that many. And so the penetration was the feature of the trial. I mean, it wasn't?
I would completely disagree with that, Your Honor. On direct examination, the victim denies the defendant ever having penetration. When the prosecutor asked the victim, the prosecutor going through the incident of the time in his room in which he locks the door, did he pull your pants down? Yes. Did his penis touch your private parts? Yes. Did they touch skin to skin? Yes. That's all about union. The prosecutor then asked her, did he ever penetrate you? And her answer was no. So at the end of the direct examination of the victim, the state has proven nothing about penetration, except for one question on cross-examination of the victim. There's never proof of any penetration. The defendant denies ever penetrating her. He denies it over and over again on the taped confession. It's not until the second officer comes in and leads him and lies to him about certain evidence, and even the judge in its sentencing stated it felt the defendant got confused with that officer in the use of intercourse and didn't believe that he had the intercourse. So we have that confusion. But when it comes down to it, we have a defective jury instruction, which the state agrees to. And it's whether or not, if that defective instruction is there, we don't know why the jury rendered a verdict that it did, and therefore, because of that, it is. And so,
you're saying that the case law specifically says that even though you didn't object to the general verdict form, that's fundamental error, and that's.
That is exactly what Sabri states. The 4th DCA just stated that a few weeks ago. Actually, it might be a few months ago now. In Sabri, on the DUI case, where they didn't object to the jury instruction, they didn't object to the general verdict form, and the jury was given an option of alcohol or cocaine, and because it didn't say cocaine to the extent normal faculties are impaired, they reversed and remanded for a new trial, and that's what we're asking for in this case. Thank you.
Thank you, counsel.